after 20 years. And my dean has now instructed me who we should start, and it's not my habit to counter the dean. So tonight, the second of our sessions, Advocate Michelle Roux from the Johannesburg Bar is our speaker. It's a great delight to introduce her. Some years ago, she and I actually published a book called Precedent and Possibility. The idea was to publish another one. Somehow, between the two of us, time has flown by. But maybe it's something that I think we hopefully will do. Apart from that, she was a member of the New York Bar and now the Johannesburg Bar, practicing inter alia competition law, and we're very happy to have her as a member of our Department of Commercial Law, where she, myself, and Dave Runterholter, the three of us, teach competition law to master students at our university when we are able to teach. But we did get 2 books actually last year. In addition to it, which is very interesting, Michelle was also counsel for the Human Rights Commission at the Marikana inquiry, which put her really right there at the centre of one of the great sort of, I think, issues which has confronted South Africa over the last number of years. So really, it's wonderful to have her here and say to you.
Thank you, Dennis, and good evening, everybody. Dean Andrews, and in particular, Justice Yaqub, who's joined us this evening. What I'd like to do tonight is introduce you to 2 concepts. The first is an idea called lawfare. The second is separation of powers. So in 2008, in the book that Dennis referred to, we introduced the concept of lawfare, which had been developed by 2 anthropologists at Harvard, John and Jean Komaroff. And they describe lawfare in the following terms. They say, politics in many societies is played out more in the courts than it is in the streets, more by the use of law and its disguised violence than by unfettered brutal force absent of any legal constraint. In an age of constitutionalism and a dominant discourse of human rights, conflicts once joined in parliaments by means of street protests, mass demonstrations, and media campaigns, through labor strikes, boycotts, blockades, and other instruments of assertion, tend more and more, if not only, or in just the same way everywhere, to find their way to the judiciary. Class struggles have metamorphosized into class actions. So the idea of lawfare is that adjudication becomes a political task. The idea is that where politics may have failed, where parliaments are moribund, where civil society is non-existent or passive, where citizenry is not engaged with the issues of the day, there will be a resort to courts. Political questions will be displaced and become lawsuits. So where you can't get your voice heard or your issue resolved on the streets through your member of parliament, by writing to your president, you instruct lawyers. Now, this is not a uniquely South African phenomenon, as the Komaroffs denote. So, for example, any of you who've had the misfortune of being involved in litigation as the litigants will know that one of the first questions that advocates get asked when a matter is set down on the roll is, who's the judge? And that matters, as we'll see, because who your judge is can often determine how the case gets determined and decided. So think, for example, of how for the last year, President Obama, it pains me to now have to say former President Obama, couldn't get the seat vacated by Justice Scalia's death, couldn't get his nominee considered by Congress. President Trump, pains me even more to say that, President Trump is likely to appoint someone very much of the conservative bent to that bench. And we all know what that would mean for important social and political questions that go to the US Supreme Court. So who your judge is matters, and matters even more when judges are in cases that would be described as lawfare, when they're in political cases. Now, this idea that judges are deciding political questions, there are two schools of thought about it. On the one hand, there's an attack on it where people say this is the juridification of politics. Judges in recent years in this country were called counter-revolutionaries. You know, these unelected high priests that decide these questions as opposed to the elected representatives of the people. So that's the one school that says judges have no business in politics. Leave it to Parliament, leave it to the executive, leave it to the politicians. But what counters that is what Penny introduced yesterday, is the obligation that living in a constitutional democracy places on our judiciary. It's the obligation on the judiciary to realize the transformative vision in the Constitution. It's something that says this is not about being above the law, unelected, unaccountable. It's a concept that says it is precisely the task of the courts to transform South Africa. They have a critical central role to ensuring that the promise of the Constitution is realized. And that's an idea that has been recognized. The most eloquent description of it was by an academic at Wits, Etienne Moreinik, unfortunately no longer with us, who described the Constitution as a bridge. And for those of you that can see, that inspired the cover image of the book that Dennis and I wrote. It's The Unfinished Bridge on the Foreshore. And the idea was that we were building and continuing to build this bridge. So the idea that Professor Moreinik came up with was the following. If the new Constitution is a bridge, and this bridge is successfully to span the open sewer of violent and contentious transition, those who are entrusted with its upkeep will need to understand very clearly what it is a bridge from and what a bridge to. If the new Constitution is a bridge away from a culture of authority, it is clear what it must be a bridge towards. It must lead to a culture of justification, a culture in which every exercise of power is expected to be justified, in which the leadership given by government rests on the cogency of the case offered in defense of its decisions, not the fear inspired by the force at its command. The new order must be a community built on persuasion, not coercion. So the idea was that the Constitution would take us from a culture of authority to the culture of justification, where decisions would need to be reasoned, they would need to be rational, they would need to advance the constitutional vision, and you would have to account. So accountability and transparency became key words in the new constitutional era in South Africa. In one of the most, in the first case decided by the Constitutional Court, Makwanyane, which dealt with the question of the death penalty, two of our justices, O'Regan and Judge Krichler, described this role of the courts in that case. So Justice O'Regan said, "The power and duty to protect constitutional rights is conferred upon the courts, and the courts should not shrink from that duty. Time and again, there will be those in our broader communities who do not wish to see constitutional rights protected, but that can never be a reason for courts not to protect those rights." So introducing the idea that however unpopular a decision may be with government or with large sectors of the society, judges have a duty, a fidelity to the constitutional vision that they must advance. Justice Krichler, dealing particularly with the controversial question of the death penalty, said, "The issue is not whether I favor the retention or abolition of the death penalty, nor whether this court, parliament, or even overwhelming public opinion supports one or the other view. The question is what the Constitution says about it." So what all of that is saying is that there is an obligation on the courts to play their part in realizing the vision of the society described in the Constitution. There is an obligation and a role for the judiciary to play in transforming our society. And the basic idea there is that, if you think about it, apartheid was constructed through law. We all recall the raft of legislation and regulations, Group Areas Act, all of those pieces of legislation that set up apartheid, prevented interracial marriage, criminalized homosexuality, determined where people would live, how the migrant labor system would run, established the homeland system, disenfranchised the majority of South Africans. That was all done through laws passed in the parliament in this town, so it was lawful. And that was the defense that the apartheid government always gave, that it had been done in terms of law. It wasn't, a system without the rule of law. You'll recall the minutiae of those regulations, the pencil test for racial classification, how public amenities could be used by different race groups. We filled the statute books with how the society would be constructed. Since then, we've filled those statute books with the attempt to transform that. And the starting point, the blueprint of that construction project is the Constitution. So if you think of pieces of legislation like those that obviously did away with all of the racial discrimination in terms of people's lives and livelihoods and where they could go to school and who they could marry, where they could live, where they could be buried, etc. That was all done through law. If you think about economic transformation, initiatives like Black economic empowerment have been done through legislation. So we're using legal materials, we're using law to transform the society. But of course, this raises this question of whether judges should be doing these political cases. And when we introduced the idea of lawfare in 2008, we grossly underestimated the nature and extent to which political cases would go to the courts. So this afternoon I sat and racked my brains for the list of cases since then that would qualify as instances of lawfare. And it's a truly astonishing list. And perhaps some of you can see if I've missed anything. But my list of cases that show you the lawfare that is underway under President Zuma's government is the following. So there are obviously the cases involving the Zuma spy tapes and the dropping of criminal charges against President Zuma. Would you like it? Would you like to move forward? Okay. Okay.
In fact, I suggest you try without the microphone, because Dennis was sounding very good without it.
What if I take it off my lapel? Is that better? No. Okay. Okay, I'm going with majority rule then. So my list of lawfare cases. The cases around the Zuma spy tapes and the dropping of charges against President Zuma by then head of the NPA, Mokotedi Mshe. The Glenister case that dealt with the Scorpions becoming the Hawks. The cases around the NPA, so the questions around Jeeba's disbarring and her suspension, as well as that of her deputy. The case around the removal of Mr. Nkosana to allow for the appointment of Sean Abrams as head of the NPA. The cases dealing with Richard Mdluli, crime intelligence boss, and Birmingham Tlemeza, head of the Hawks, and whether they are fit and proper people to hold positions in those institutions. The cases around SARS, the rogue units, the so-called rogue unit, and the cases around terminations of employees of SARS. The Nkandla saga, Marikana, President al-Bashir's departure from South Africa without arrest, the subsequent review of our decision to withdraw from the International Criminal Court so that we wouldn't have those kind of obligations, the litigation around the SABC and Claudi Motsoeneng, the cases around the landing of the Gupta wedding party at Waterkloof, the interdict by the president and 2 ministers withdrawn and reinstated to prevent the public protector releasing the state of capture report, the review instituted by President Zuma of the state of capture report, the cases around conduct in parliament, generally involving the EFF. Those cases are about, parliamentary rules as well as cell phone signal blockers and the presence of private security in the chamber, all of those cases. The case brought by KSAC about the Financial Intelligence Center Amendment Bill. This is the piece of legislation that would enable the Financial Intelligence Center to collect information from the banks about politically prominent people. Tomorrow in Parliament is a hearing before the committee about whether that piece of legislation should be enacted and is constitutional. The case brought by Minister of Finance Pravin Gordhan against the Oak Bay group of companies, dealing with their bank account closures. The arms deal series of cases. Cases involving our state-owned enterprises, PRASA, Eskom, SAA, Denel. The e-tolls saga in Gauteng. The cases around Robert McBride and the Zimbabwe extradition report. And finally, the cases around the nuclear build. That's my list. And it's a pretty astonishing list, that this is the type of political questions that the courts are being asked to intervene in. Now, the concern is that it creates too much pressure on the judiciary, that this is not appropriate for judges to be dealing with these questions. There's also, of course, the answer that says, no, it's precisely what they need to be doing. And the reason we say it's precisely what they need to be doing is because, as lawyers, we think about the role of the judiciary through the second concept I want to introduce to you tonight, separation of powers. So the idea is that the Constitution allocates between 3 arms of government the powers of state. So that's between the executive, the legislature, and the judiciary. What that allocation of roles involves is a balancing act. There needs to be deference between those arms of government, and there needs to be respect for the boundaries of each of their job descriptions. So if we took an example, just because it's happening tomorrow, the FIC Amendment Bill, what happened there was Parliament passed the legislation that would allow the FIC to collect this information about politically prominent people. They then send it to the president for his assent, his signature. If he thinks there are constitutional problems with it, he has to send it back to Parliament. That's what he's done. Parliament then consider it. If they decide it is constitutional, or they make further amendments to the bill to make it constitutional, they then send it back to him. He's then under an obligation to sign, or if he still has concerns, send it to the Constitutional Court. The Constitutional Court will then look at those issues and determine what would be the constitutionally appropriate provision. Once the Constitutional Court makes that decision, and let's assume they approve the text, then the president is obliged to sign. So that's a pithy example that shows you how the 3 arms of government would interact with each other and how they must hold each other accountable and how they're in a dialogue to try to balance their different functions. I mean, topically today, the Supreme Court in the UK has ruled that Parliament has a say in Brexit. Obviously, that's a very different system because they have parliamentary sovereignty, but it's the same idea. What can the executive do? What can judges do? What can the people do? And you've seen, I'm sure any of you who followed it, you've seen the attacks on the High Court judges who said that Parliament needed to have a say. It's precisely the same question. How does separation of powers work on these big political questions? Our Constitutional Court, in the outer decision, which is the e-tolls case, describes separation of powers in South Africa in the following way. So they said, where the Constitution or valid legislation has entrusted specific powers and functions to a particular branch of government, courts may not usurp that power or function by making a decision of their preference. That would frustrate the balance of power implied in the principle of separation of powers. The primary responsibility of a court is not to make decisions reserved for or within the domain of other branches of government, but rather to ensure that the concerned branches of government exercise their authority within the bounds of the Constitution. This would especially be so where the decision in issue is policy-laden as well as polycentric. So what we're saying is that the exercise of public power is subject to the Constitution, but it doesn't mean that the courts will usurp the executive's function and determine policy, or the legislature's function and write every piece of law that would govern the lives of South Africans. And so we see in cases where courts will declare something constitutionally invalid and then give Parliament a year to come up with a piece of legislation to meet that problem. That's the deference that I'm talking about. That's the balancing. We saw it in Nkandla. The court decided it wouldn't go all the way in making its decisions. It deferred and left some things to Parliament and said, for example, some of the Speaker's conduct and the like were questions for the legislature to deal with, not appropriate for the court to deal with. So it's policing those boundaries that we're interested in. So to tie the two together, to tie lawfare and separation of powers together, the idea is, when is a case more appropriate for politics and shouldn't be sent to the courts all the time? So, for example, I have a concern at how often our opposition parties are the applicants in some of this public interest litigation. The DA and the EFF go to court regularly, but we have a very active civil society that it may be more appropriate to be the applicants in some of those cases. So if you think, for example, of some of the rule of law challenges that have been done by organizations like Freedom Under Law, Corruption Watch, etc., perhaps it's more appropriate for civil society to do that and for political parties to use Parliament as the venue to try to challenge these questions. So I do think there is some hope, though, on our political arena. So we see things happening that should certainly give us encouragement that we are not a country where the courts are going to have to determine every question and hold the line on every issue. So I have 4 rays of hope for you here. The first is obviously that we have very active NGOs that are litigating now on these critical questions, not just on socio-economic rights questions. So we're getting the rule of law cases being brought by civil society. Secondly, I think our media are doing an excellent job at educating South Africans about what is going on. Obviously, there are elements of capture. Obviously, certain outlets undoubtedly have a certain agenda that they're trying to push. But generally, our media is performing their function, and you've all heard them referred to as the fourth estate. It's an analogy to the separation of powers idea, that if you have a free press that are diligently holding public officials to account, that's a part of a vibrant democracy and political debate. On the topic of the media, I was recently in Ireland for a friend's wedding, and on the front page of the Irish Times, the biggest newspaper there, was a full half-page story that then continued with contested op-eds inside the newspaper. And it told the story of a dispute that is tearing apart communities in one of the towns in Ireland. Neighbor against neighbor, parent against child, in terms of how they felt about this issue. And it wasn't any of the things you would think Ireland would be debating. It was the landscaping options of a new roundabout in town. Should it have flower beds? Should it have lawn? That was the front page story, and I remember thinking, I want to move here. Because when we pick up our newspapers every single day, we see issues that, for a lot of them, are heading to court. Thirdly, I think we've started to see the end of parliamentary paralysis. Partly it's thanks to the EFF, and partly it seems to be thanks to the ruling party paralysis coming to an end. So we seem to have a caucus chair who is interested in the role of Parliament and holding the executive accountable for the ANC, Jackson Mthembu. We've seen, for example, the SABC inquiry that they've conducted, which is unique because it hasn't happened before, but that is precisely the type of hearing and the type of inquiry you would hope to see from an active Parliament holding the executive to account. And then there was also, of course, the public protector process that took place. Now, whatever concerns we may have about the outcome of that process and the new incumbent in that office, the process that Parliament went through to shortlist and interview and assess candidates was, again, unique and precisely the type of thing you would want Parliament to be doing to ensure that your Chapter 9 institution that is so important has the right person at its head. And then lastly, I think we see on the political landscape itself, local government election results and the rise of coalition politics is another way in which you're not going to have this moribund, dominated, political landscape dominated by the ANC. You're starting to see shifts in power. You're starting to see the ANC being in opposition. You're starting to see coalitions having to be built around contentious issues. And all of that creates vibrant opportunities for politics to deliver good results on realizing the constitutional vision, but through parliamentary processes and local government processes. So what I'd like to do to close off, and then obviously we'll do questions, is to pull it all together using a recent case that the SCA decided on the question of euthanasia. So there was an urgent application brought, and it was urgent because the man in question was suffering from terminal cancer. So there was an urgent application brought that sought an order from the court that he was mentally sound and able to make decisions. He was competent in the language of lawyers, and that he wanted to have the assistance of a qualified medical doctor who was willing to do so, to end his life either by the doctor administering a lethal agent to him or the doctor providing him with the medication that would enable him to end his life when he felt he wanted to. Now, what that means is that our common law around murder and culpable homicide would need to be developed. Because while suicide is not illegal in South Africa, obviously murder and culpable homicide is. So if you help somebody kill themselves, even though from their perspective it's suicide and not an unlawful act, your assistance to them could be criminal conduct. The High Court gave the order, and it then went on appeal to the Supreme Court of Appeal in Bloemfontein, and it now will go further to the Constitutional Court. And the SCA decided that the order should not have been granted for 4 reasons. The first was that because the applicant had died by the time the High Court gave judgment, there was no longer a cause of action before the court. There was no case before the court anymore. This was a personal request of the court by this man. It didn't transmit to his estate. So because he had died, there was no longer a case in front of the court. So the first reason was they said, there's nothing here. If he had still been alive, obviously there would be his personal case to determine, and that would have some precedential value for other cases, but there's nothing in front of the court now. The second reason was saying that bringing it on an urgent basis was inappropriate. So given the complexity of the issues, the need for detailed evidence from experts, the need to understand precisely that he was of competent mind and truly suffering and truly understood what he wanted to do, and that, interrogating all of the policy questions around whether he should be, the doctor should be liable for murder or culpable homicide, these were just too complicated to do in an urgent court on an urgent basis. So urgent courts are, they sit all hours of the day and night because of matters that are urgent. The child that is being taken to the airport as we speak to leave the country. That is an urgent case. Obviously, the man's illness made the matter urgent, but the court was very concerned about the rush and the pressure and not being able to interrogate the questions closely. Related to that was the concern that they simply didn't have enough evidence or facts about his predicament. They didn't have the medical evidence that they felt they needed to determine whether it was appropriate for him to get the order that he had sought. But then lastly, what's interesting is the court becomes concerned about the values that this reflects. And the court talks about how South Africa shouldn't be considered the same as countries where assisted suicide or euthanasia is permitted, so countries like Switzerland, states in America like Oregon and Vermont. And there was this concern that something in South Africa and South African values would not be appropriate and didn't match those first world countries with their far more developed and accessible healthcare systems. There was a concern that in rural, poor South Africa, this might result in people being euthanized who did not actually want to be. There was a potential for abuse in these communities in South Africa. But what this case essentially boils down to, and what it shows, is that judges were being asked to determine these incredibly complicated personal, moral, and value-laden questions. The courts were being asked to, in a sense, apply their own values and their own personal attitudes. Whether a judge is religious or not, whether a judge has had the experience of having to give palliative care to a close family member who's terminally ill and understands what it would be to be in that sort of predicament and suffering. Whether a judge has, any experience with medicine and what could and couldn't be done. Whether they've had somebody close to them commit suicide and how that impacted their lives. You can see how all of these questions come through in the court's judgment. All of these concerns held by the judges come through. And the question is, it takes us back to, who's your judge? Because you could imagine a judge that said privacy, autonomy, dignity, freedom, and equality of an individual are paramount. This is the idea that the legal philosopher Ronald Dworkin explores in his book Life's Dominion, which deals with abortion and euthanasia. So if you're somebody who thinks that an individual's dignity and freedom should permit them to choose, there should be the physical integrity right that Penny discussed yesterday can be applied to this. Yes, we have a right to life, but for example, abortion is legal in South Africa. So we accept that there are limitations on rights where it would advance a woman's dignity, autonomy, freedom, and equality. So does euthanasia fall into that type of issue? Is it a dignity question for the person involved? On the other hand, you could see judges who think this is a religious question, that all life should be protected, that there's a good reason why the criminal law prevents someone assisting with a murder. And you can see the limitations as well of the legal materials in front of the court. So if there isn't adequate evidence, as the court found here, that Mr. Strantham Ford, which was the man's name, that there wasn't sufficient evidence about exactly how much he was suffering and how a particular lethal agent would kill him, and whether that would be a traumatic and painful experience. The court found that the lack of evidence about his mental state and the attitude of the doctors that may be called upon to either administer the drugs themselves or provide the prescription. All of these questions you can see percolating in the decision. And it's exactly that type of issue that the court then says, Parliament must decide this. It's not something that the courts should stray into. So I think ending with that example, and then I think we can debate it or anything else you'd like to debate about lawfare and separation of powers. These questions there are no easy answers. And you can see both sides of the argument. And as Judge Kreckler said in Makonyani, it's not about what I think or what you think. It's about what the Constitution thinks. But of course, that's a pithy, easy answer because it's contested. The Constitution says you have a right to life. What does that mean when it comes to euthanasia? Does that mean you can never have euthanasia? Or does that mean the type of life that I have a right to must be a quality life, one free of suffering? And that is what judges were called upon to try to answer. So that's a bit of a preview for a watch this space, because that case is going up to the Constitutional Court, where they will have to decide whether it's a question they can determine one way or the other, or whether they will set out guidance and then defer it back to the Parliament for it to decide. So I don't know if there are any questions. Yes? Yes.
Who all gave evidence? Did they get family members to give evidence? Did they ask doctors to give evidence? Did they bring people from countries like Holland where they have a much open policy on euthanasia?
The case is... Yeah.
I ask this because I remember cases in the radiotherapy department where people were not being what they call held by treatment. And it was then decided that there was no point in carrying on with treatment. In other words, your life proceeds to get worse. Is that what is that?
Well, let me start with that. So withholding treatment, or the decision to turn off the machines, as we hear it described, that is lawful in South Africa. So refusing treatment, because it's akin to a suicide, that is lawful. But to go back to your question on evidence, because it was brought in urgent court, there was evidence, from the family, from him, from his doctors about the nature, he had cancer, about the nature of his illness, the suffering caused by treatment and where he was in the lifespan of that disease, the burdens and all the rest of it. There was not detailed evidence, because of the urgent nature of the case, around euthanasia and all of its policy questions. So when it went on appeal, a number of parties and NGOs came in to assist the court. So you've heard this idea of an amicus curiae, a friend of the court. So there were 5 amici that came into the case on appeal. 2 of those were anti-euthanasia, and the remainder were pro-euthanasia. And they put before the court comparative materials, so looking at other jurisdictions where euthanasia is allowed, how the policy has been regulated, what type of evidence has been looked at and is required. There are regimes where courts still need to give that authorization and what they would look at. There are other ones where it's sort of a generic framework that gets described and established. So at the appeal stage, there was that sort of policy evidence, if I can call it that. But obviously there was no more factual evidence about the particular applicant because he had died. And that was therefore one of the difficulties the case had, that the legal materials in front of them ran out. They could not determine the question in his particular case. You had a question, yes?
It might be a bit off track, but how does our Constitution fit in with the sort of American controversies going on about reproductive rights?
So obviously there are a series of rights in the Constitution that would be implicated around if you talk, obviously that's sort of contraception and abortion. So abortion is legal. It's a justified limitation on the right to life. Contraception, of course, is also legal. If you thought about it from a human rights perspective, obviously you can see the rights that it would target. So a woman's right to equality, a woman's right to physical and bodily integrity. There are also rights to family life and parental care. Those kind of issues would be involved in that case. So the questions around, so we don't have, I think because we don't have as much of a religious political lobby that's identifiable and is latched onto issues, we don't see the same type of debate that you see in the States around those questions. Certainly there are, NGOs and churches and the like that hold the view that it should be outlawed, but they haven't sort of got themselves organized to challenge it, and if they did, you would see the debate unfold in the courts. And that would again be a very interesting question that would the courts seize it and say, no, there's a constitutional framework for these things, we're going to determine it in a particular way, or would they kick it to Parliament? So if you think about same-sex marriage, the Constitutional Court looked at those cases, and it was done incrementally. So there was a case that dealt with whether a same-sex partner could inherit. There were cases about whether same-sex partners could adopt children. There were cases about the ability to be part of benefits packages. And incrementally, that case law was built up, and then we got the challenge on same-sex marriage. And the Constitutional Court decided that they would create something that was exactly the same as marriage in all senses, but it was called a civil union. And there was a separate legislation drafted for that. So rather than amend the definition of marriage, we created a mirror image of that for same-sex partners. So you could see the same type of approach being taken with some of the reproductive rights questions. Yeah.
I was amazed by your list of the lawfare topics that have come up. Can you help me understand in this country how the court, what the processes the court has for batting away the frivolous ones?
Well, the problem is the biggest deterrent, of course, would be an adverse costs order, but those, if you're using taxpayers' money, that doesn't really deter you. And that's why you're starting to see the courts award cost orders against individual politicians or office bearers who bring cases. So in terms of, most of these cases are launched as applications. So in South Africa, there's a distinction between action proceedings, so plaintiff suing a defendant, and application proceedings, so applicant-respondent. The one is where something will ultimately go to trial and probably have witnesses and the like. The other is determined on papers. So when you see the affidavit being quoted on the front page of the newspaper in a particular case, that's an application. Those have to be heard. So as long as there's a cause of action and the matter is joined and it's ripe for hearing and all the rest of it, the courts have to hear those cases. They then determine them, and then you see the endless appeals. So obviously in South Africa, you go from the High Court to the Supreme Court of Appeal to the Constitutional Court. Now, there are mechanisms that filter at every stage. So the appeals are not automatic. They are in certain circumstances, but generally there's this idea of leave to appeal. So you lose in the High Court, you bring an application for leave to appeal to the Supreme Court of Appeal. That's a contested hearing. Could another judge reasonably come to a different conclusion? That's the test. That's what you have the debate about. If you decide that you have leave to appeal, then you can approach Bloemfontein. If leave to appeal is denied, you do another application to Bloemfontein, to the Supreme Court of Appeal. It's called a petition. So you say, the High Court biffed us, the High Court said no leave, but we still think you could come to a different decision, please give us leave. The SCA can turn you down, and then your case ends at that point. Oftentimes the SCA will say, maybe, or it's interesting, more interesting than what they'd done the rest of the week, so okay, come. Then you go to the SCA. Then from there you would go to the Constitutional Court. And in the Constitutional Court, again, there's a category of cases that have to go. Otherwise, again, there's an application procedure, and the judges, Justice Yakub obviously has first-hand experience of this, but the judges do then look at, it's called the conference, so they look at the applications that have been received, the issues that are there, and they determine whether it's a case that they will hear. So you've heard, I'm sure, press reports where the Constitutional Court has turned down hearing a case, and then it ends. So then the Supreme Court of Appeal decision would be the final determination. But of course you raise a critical question around access to justice. So the cost of lawyers, the difficulty of finding lawyers who will take your case, the adverse costs order if you lose, because in South Africa, loser pays generally. There are categories of cases, again, often constitutional public interest cases where that's not the case, but oftentimes costs follow the result. But for example, in a country like Colombia, they have a thing called the To Tailor System, which is any one of us, if we were Colombians, could write to the court and say, whatever, my child. You can write and say, I've got this problem, my child's school is terrible, and you need to do something about it. And the court collects these things directly. It's almost like letters that come, and there are thousands, tens of thousands of them come. And the courts work through all of them, and they group them together into themes and patterns. So when they start seeing that they're getting lots of complaints about a school in a particular area or province or whatever, they'll say, right, we're going to have a case about that. And they become quite inquisitorial, and they go, no, that's clearly not working, we're going to have a hearing, what's going on with that issue? So in terms of access to justice, there are very different approaches that would enable a lot more access. So we followed something, like in America, you'll hear about how the Supreme Court takes so few cases. Same thing, they have what they call a certiorari procedure. So you have to ask for permission to come on appeal. And they take a tiny fraction of the cases they get. But something like the To Tailor System would mean courts would very proactively be looking at what's going on, and they could call for a case to come to them. So yesterday there was the question about how do we make sure that these issues get to court? And that's the very problem. So, for example, this euthanasia case, if the first reason why the appeal was upheld is right, i.e., because he died, there's no case in front of us, the issue of euthanasia will not be determined until someone brings another case. So so there are these filters, and courts will recognize a vexatious case or a frivolous case, but you have a fairly long road before you get to a final point.
So somebody then in retrospect, it will appear to be managing, like you were saying, that the gay marriage, a whole lot of cases built towards an outcome.
Yes.
That's not random.
No. So what you see on a lot of these questions, particularly socioeconomic rights cases, is you see NGOs that are single-issue NGOs, so Treatment Action Campaign on HIV/AIDS, or Section 27 on education question, equal education, Section 27 on health issues, Equal Education, who do all the textbook cases. Oh, we should have added textbooks to my list. NGOs will have a strategy of let's go incrementally, but also, South Africa is a tiny place, so all the public interest lawyers, we generally know each other, and we'll leverage off what other people are doing. Oh, so you got, that part of the right developed and recognized, I'm going to leverage off that in the next case. Obviously, the sort of lawfare cases, the political cases, those are happening again. You see the same NGOs litigating over and over again, and then obviously the political parties. So there's coordination because it's what they're interested in. It's their mandate for what they want to do. Yep.
In the context of who's the judge, if you look at the state capture report, and there's a request for a commission, and the judge to be appointed by not the president, and clearly a big conflict of interest there. My understanding that the president's defense is that in terms of the Constitution, he's the one who appoints commissions, and he's the one who would appoint the judge. Even despite this big conflict of interest. Now, is that the true situation, or can this be altered?
Justice Yakub probably knows the section off by heart. But the president, in section 84 to F, powers and functions of the president. The president is responsible for, and F is appointing commissions of inquiry. So he has an exclusive job description that runs from A to K. And so the argument is that is an exclusive presidential power that only he can exercise. The counter to that is the conflict of interest, and you can't be the judge in your own case. And so therefore the idea in the Public Protector's report was to let the Chief Justice appoint, well, to make the Chief Justice appoint the judge, that the President, so the Chief Justice would tell the President who to appoint, and the President would have no discretion to appoint. Before I violate bar rules, I must say I'm acting for KSAC in that case, so I mustn't talk about a pending case. But yeah, so his argument is there are certain things that are reserved to the presidency, and nobody else can tell me what to do with those powers.
Is that a gap in the Constitution? Is that a problem?
I'm going to look at Dennis as one of the drafters of the Constitution. I think they never expected the president to need to investigate himself. I think we were all high on Mediba magic at the time and couldn't conceive of the scenario where, the president would be the one who would need to be investigated. But it's a structural problem in the Constitution, but obviously, again, I must be very careful of not sort of saying anything that would violate bar rules about pending cases. But, you could see an argument through that says, no, in these circumstances, accountability, rule of law, all of these questions require this workaround, even though it is not in the express terms of the Constitution, it's necessary in these circumstances. At the back.
I've got a couple of questions following on from that, really. The one relates to what powers does the Common Court have for people who abuse it?
Costs orders.
Particularly of the state capture, which was used as a delay tactic, essentially, and it cost the taxpayers a hell of a lot of money. And at the end of it, the case was dropped. The other one was, I think, when Zulu was ordered to pay back the money by a particular date. That date came and went, and there was no payment.
No, he has paid back, because remember, he got his loan from VBS Bank that no one had ever heard of.
But the central question is, what power does the Common Court have to deal with abuse of the court process?
So, costs orders are the sort of easy answer. There is the system, as I described, where they can refuse to hear a case that's clearly going nowhere. But you also, obviously, and this is always the tension that I'm becoming concerned about, is we're making decisions about people, not necessarily about the institution. And my favorite example of this is precisely Nkandla. So we all love Nkandla because of what it did and how it held the president accountable and how it confirmed the powers of the public protector, but we love that case when the public protector was Thuli Madonsela. Now we're not so sure that we want a public protector with all these powers. And the problem is we litigated that case for Thuli, not necessarily for the institution. But of course, the context, the circumstances absolutely required that outcome of the case. And that's the type of stuff that you're seeing judges navigate. And that's precisely the concern about it makes me very anxious that judges are having to make these kind of calls. So, judges are people too. They, apparently, according to Dennis, they read the newspaper, they get cut full with what they read. They can't unthink that when they don their robes and go into court.
Can they curtail the powers of can the Common Court curtail the powers, go back to separation of powers? Do they have that authority? To cut the president's powers, to cut the public protector's powers?
So things like that, some of them would require constitutional amendment, which would be a parliamentary process. So that shows you how the separation of powers will work. So there may be, and some of those amendments would require, the 2/3 majority in Parliament. So there are those kind of safeguards built in for precisely those reasons. So we could imagine a case where the Court says, clearly this is unconstitutional, and the only way to fix it is a constitutional amendment. Parliament do the necessary. So it would still be the split. But, back to your frustration, and I share your frustration, but we don't want a constitutional court that says, everybody knows this case is an abuse of power and it's just designed to be a dilatory tactic and we're not going to hear it. You can't have courts picking and choosing which case to hear. You can have them indicate displeasure through a costs order, or indicate concerns about abusive process or make a finding of abusive process after a hearing where both sides have been able to argue. You don't want capricious judges. That would be a very, very dangerous road. I've had that experience in our neighboring kingdom of Swaziland, where the judicial system was very dependent on the identity of litigants. And we definitely don't want to go that road. Yeah. Well, that's on ice. Has been for years. I should have added that to the list.
Is there any prohibition against crowdfunding?
No. I mean, Arta, for example, in the ETOLS case, ran a fundraising campaign. Corruption Watch, to run the public protector process, also fundraised. It's not you can't fundraise to pay me, but you can fundraise to pay the NGO that briefs me. That's.
Could an individual use that kind of fundraising for their own case?
Yeah, absolutely. And that has happened. Yes.
There's sometimes issues that sort of me and that death penalty where they sort of say the Constitution needs to change. And I know the Constitution, last time, it's got nothing to do with majority rule or anything. There are clearly parliamentary processes that can change the Constitution. And then, so what are those? And then can the Constitutional Court ever, given the separation of powers, ever tell Parliament they can't change the Constitution? I mean, what is the, I suppose what I'm trying to say is, what is the boundary, what's the closeness, the protection of the Constitution?
So it's precisely the iterative process between the three arms. So you could imagine Parliament. Let's go back to the days when the ANC were above 2/3. They could have, as a party, amended the Constitution without having to persuade any opposition party to join them. They had the majority. So let's assume they did some crazy amendment to the Constitution. You would then challenge that in the Constitutional Court. It could then determine whether that was appropriate or not. If not, it undoes it. So it's that dance between the three arms of government that would have to carry on. But
Nobody could have final say. I mean, would the Constitutional Court be able to tell Parliament, no, you can't change the Constitution?
yes, and then Parliament could try. So that would finally determine that amendment. Then Parliament could try it a different way, and you would run the process all over again. So that's how that political process works. That's how the accountability, the checks and balances would work. So Parliament could give it a bash. Concord could say, no, that's the end of that attempt. Then you do it. They would do something different, and it would go back. Obviously, the Constitutional Court also has, supervisory jurisdiction. So you see, for example, in the social grants case, this whole case about who dispenses the grants. There, the court has exercised supervisory jurisdiction. So the parties keep having to go back to the Constitutional Court and telling them what they're up to, what's going on with the tender process, what's happening with that exercise. So there are mechanisms like that, but they are used, but not. Kandla did that as well. remember the judgment said Treasury, i.e. the executive, different branch of government, go back and determine what a reasonable payback is. Come and tell us. Okay, it's reasonable. That's what you have to do. So there are those kind of mechanisms, but it's a slow, iterative process. I'll do the last two. Yeah. And that, of course, that's why the judiciary is referred to as the weakest arm of government. Because what do it's like the little kids where which armies? These armies. The court can't compel compliance. The court's